The most fascinating piece of evidence for me as a lawyer is indeed the expert witness, because the expert witness does not tell the court anything about what he or she saw with her own eyes, heard with her own ears, etc. The expert witnesses are telling the court something that they have not witnessed. So basically the idea is that people can only testify to what they have sensed themselves. The expert witness is not testifying to what they sense themselves, but to conclusions that they have inferred from their experience, from their knowledge. And so they need to ascertain that they have this experience, they have the unique knowledge that enables them to make these inferences. You cannot take the case out of a context. And the context was the 2008-9 CAST-led operation in Gaza, in which, according to the figures of human rights organizations, about 1,100 people were killed, 400 of them children or something of that sort. I don't know exactly by heart the numbers. And use of white phosphorus was documented heavily by different international and Palestinian and Israeli human rights organizations. White phosphorus is a substance that when comes in touch with, exposes to oxygen, it burns. And I think that the use of white phosphorus was to intimidate, to scare, and to burn down some civilian objects. It's an area rather than a pinpointed weapon, so it covers an area. It has a radius of effect, and it has an effect temporally, meaning in time. While a regular conventional bomb hits and then explodes, the white phosphorus continues to burn, and sometimes it burns for days. We did not want the case to be a case in which the use in Gaza would be adjudicated, because this is a post facto case and the court would never agree to adjudicate it. What we wanted is having the experience of Gaza, getting a remedy that will prohibit the use of white phosphorus in the future. And the case revolved around the question of whether there is a legitimate use of white phosphorus munition in a civilian area, in an area that is inhabited by civilians.
What we wanted to show with the spray, the sort of range that the white phosphorus has when it hits the ground, is to show that this is, by definition, a weapon that cannot distinguish. And what we mean by distinguish is distinguish between civilians and legitimate military targets. In the report, we have comparisons to other cities that are not as densely populated, but still we have comparisons in the report to New York, to Tel Aviv, to Paris, and we are able to see that even in those cities, which are in some cases less densely populated, the damage would be unthinkable.
The state has objected to admitting the report as evidence. It has objected to it on the basis that the expertise of its authors has not been proved. Not that they're not experts, but it is not proved that their expertise allows them to make the specific inferences that they have made in the report.
The military prosecution did everything it could to try and discredit this report and to try and push it out of the realm of expert and expertise. And that was a battle that we had to fight that we weren't anticipating. The court still saw it, and that is something. That's a lot, in fact. We got the military to see it. We got the legal team that represents the military to see it, and we managed to at least get 3 Supreme Court judges to review that material. And those are the same Supreme Court judges who then later gave us what we think is a very favorable ruling.